Welcome to our examination of the U.S. Supreme Court today. The decisions of the U.S. Supreme Court's 9 justices are binding on all other courts in the country, and no other court may overturn them. Decision-making on the court is a multi-step process that provides many opportunities for conflict and compromise. As a collegial court, which means it is made up of a panel of justices, Supreme Court justices must work closely together as they navigate the process. The need for compromise on the court is especially intense because of the sheer number of cases it hears and the fact that its decisions are final. In the vast majority of cases, the Supreme Court is reviewing a decision made by a lower court rather than exercising original jurisdiction. The framers limited the Supreme Court's original jurisdiction to only those cases that concern ambassadors, public ministers, and consuls, and those involving 2 or more states. Let me repeat that. The framers limited the Supreme Court's original jurisdiction to only those cases that concern ambassadors, public ministers, and consuls, and those involving 2 or more states. You might want to pause, rewind, and write that down. But over time, Congress, this is an important distinction, in cooperation with the court, has decided that the court should retain original jurisdiction only in cases involving suits between 2 or more states. Approximately 7,000 petitions are filed with the court each year, each asking for the review of a case already decided. Each case is one that a party or parties are appealing from some other court because one or both sides dispute the decision in the case. Ultimately, the justices write decisions in only 80 to 90 cases, however. How do they decide which cases to hear? Like the other stages of the decision-making process, deciding to decide, as Supreme Court scholar H.W. Perry puts it, is a joint activity. The decision to place a case on the Supreme Court's agenda is a collaborative one. Important in this process is the role of the Supreme Court clerks. These young lawyers, who are recommended for the positions by certain feeder professors at selective law schools, are charged with drafting a pool memo, a description of the facts of the case, the pertinent legal arguments, and a recommendation as to whether the case should be taken. The Chief Justice distributes a list of selected cases, the discuss list, to the other justices before a regularly scheduled conference. A Chief Justice's decision as to whether to include a given case on the discuss list is based primarily on review of the Supreme Court's clerk pool memos. On Fridays throughout the court's term, which lasts from October to June, the justices meet in conference to discuss the cases on the list. At this point, they vote on whether to issue a writ of certiorari, or a writ of cert, a Latin term roughly translated as a request to make certain, for specific cases. The writ of cert is a higher court's order to a lower court to make available the records of a past case so that the higher court can determine whether mistakes were made during the lower court trial that would justify a review of the case. The writ of cert falls within the court's discretionary jurisdiction, meaning that the court can choose whether to hear such cases, unlike those cases that have a mandatory appeal to the U.S. Supreme Court. The justices determine whether they will consider a case according to a practice known as the Rule of 4, under which the justices will hear a case if 4 or more of 9 justices decide they want to hear it. They do not need to give reasons for wanting or not wanting to hear a case. They simply must vote. The vast majority of the cases the court hears reach the justices through a writ of cert, reflecting its role as a primarily appellate court. When a case makes its way onto the court docket, the parties in the litigation shift into high gear. The petitioner, the party that sought the court's review in the first place, usually has 45 days to file a written brief, a document detailing the legal argument for the desired outcome with the court. After the filing of this brief, the opposing party, the respondent, has 30 days to file its own brief with the court. Today, amicus curiae briefs are a common part of Supreme Court litigation, filed within a specified time period by a person or group that is not party to the lawsuit. An amicus brief or friend of the court brief is a document that aims to influence the court's decision. Some cases trigger the filing of many amicus briefs. The largest number of such briefs, 90, ever filed in a Supreme Court case, came in 2 cases involving affirmative action at the University of Michigan. Just as an aside note, there were 30 of them filed in the Citizens United case. Amicus briefs seek to provide information that jurists need to resolve cases and can be very influential. In the University of Michigan cases, a wide variety of interested parties, ranging from MTV Network to the Law School Admissions Council, filed briefs describing their views on how racial equality has been and can be achieved in various settings. Judges often use the information or the legal arguments contained in an amicus brief to decide cases. The use of these briefs democratizes the judicial system by opening up to lobbying that is similar to lobbying in the other branches of government. And the participation of interest groups and other organized interests in the judicial decision-making process provides an avenue for citizen engagement and civic discourse. But the playing field for these groups is not level. Like lobbyists in other branches of government, some groups are more influential than others. Elite interest groups, benefiting from members' influence and richer resources, are likelier to have their views heard in a court case than groups with less privileged members. In docketing a case, the clerk of the court selects a date for oral arguments. Attorneys formal spoken arguments that lay out why the court should rule in their client's favor. Heard in the Supreme Court's public gallery, oral arguments give the justices the opportunity to ask the parties and their lawyers specific questions about the arguments in their briefs. In typical cases, each side's lawyers have 30 minutes to make a statement to the court and to answer the justices' questions. Although the public gallery is very grand and the mood is often somber and formal, the justices can sometimes be less than polite towards one another and their lawyers during the oral arguments. The justices frequently interrupt attorneys during their opening statements and responses to questions and sometimes seem to ignore the lawyers entirely, instead talking with one another. This discourse takes place entirely within public view, and transcripts, and sometimes even tapes, are readily available to the public. After the justices have listened to the oral arguments in the case, they meet in conference to deliberate. At this point, each justice will signal his or her likely vote on the case and discuss the legal issues in play. We have few clues as to how the justices interact in conference because those proceedings are entirely closed to the public. The late Chief Justice William Rehnquist once described conferences in which the most junior associates justices was seated closest to the door and was charged with answering any knocks on the door that might come about during deliberation. But other than the anecdotal descriptions we have from justices, once a case enters this phase, it is kind of a black box. We can only guess how the justices deliberate and make their decisions, because there is no public record of the proceedings. We do know that the justices must work together at the deliberation stage if they hope to reach a decision that a majority of them will sign. Because cases are decided by a majority rule, there is a strong incentive to cooperate. The Chief Justice plays a vital role in this process. After the likely votes of the other justices are tallied in the conference, the Chief Justice decides whether he is with the majority. If he is, he chooses whether he wants to write the majority opinion. If he declines, he can assign the task to one of the other justices in the likely majority. If the Chief Justice is not with the majority, the senior member of this majority decides whether to write the opinion or assign the opinion to another justice. By the time the justices have finished with the conference, they will have already read the briefs in the case, heard the oral arguments, and listened to one another's views. In assigning the majority opinion, the senior member is effectively giving a stamp of approval to the view of the case that either he or she or some other members of the court has articulated. The assignment of the opinion is a crucial stage. The justices who write the opinion must consider the positions of the other justices, especially those who are likely to vote with him or her in the majority. No justice who is assigned with the writing the majority opinion can afford to ignore the policy views of the other justices. At the opinion writing stage, the justices must cooperate and try to hammer out a decision that at least 5 of them will agree to. Their discussion about the case often centers on the legal arguments that the parties have advanced or on the underlying factual issues. How does each justice decide how to vote in a particular case? Frequently, the justices vote in blocks. Those with similar views tend to vote together, especially in similar cases. By the late 1990s and early 2000s, Supreme Court watchers could predict with a great deal of certainty how specific justices would line up to vote in cases involving abortion restrictions, for example. These voting blocks work as a kind of shorthand for the justices, who often look to other like-minded justices to decide how they should vote in certain cases. In cases involving broad areas of the law, such as civil rights and civil liberties, and in cases concerned with the separation of powers, the justices are remarkably predictable. Their decision-making follows patterns, with many justices voting together term after term. For example, in case after case brought before the Rehnquist Court from 1986 to 2005, when Rehnquist was the Chief Justice, 4 of the 9 justices lined up on each side, and Justice Sandra Day O'Connor cast the swing vote that determined the outcome in those closely divided cases. In terms of political stance, we tend to talk about the justices as either conservative or liberal, with conservative justices tending to favor the state and state interests in cases involving civil liberties or civil rights, and liberal justices tending to favor the individual in these cases. The justices are arrayed in groups on a kind of spectrum, and Justice O'Connor occupied the central position for many years. Because the court was so closely divided, she exercised significant power in the decision-making process. At the opinion writing stage, give and take comes into play among the justices, especially if the case is particularly close so that the justice writing the majority opinion must lock in all the available votes. This is an important consideration because at this point, the justices are still free to change their mind about how they will vote or whose opinion they will join. Although there are no records of the justices' deliberations, it is likely that the first draft of most majority opinions is modified to reflect the desires of at least some of the justices who agree to sign it. There are significant incentives for the author of the draft opinion to take into account the perspectives not only of the justices who agree with his or her conclusions, but also of those who disagree. The reason is that the majority draft may not be the only draft circulating among the justices. When the justices disagree about a decision, it is likely that other drafts also circulate. Concurring opinions agree with how the majority opinion decided the case, but disagree with at least some of the legal arguments or conclusions reached in this majority opinion. Dissenting opinions not only disagree with those arguments and conclusions, but also reject the underlying decision in the case. As drafts of the majority, concurring, and dissenting opinions circulate, the justices continue to gauge the level of support for each. It does not appear to be unusual for majority opinions to become concurring opinions and vice versa. Again, the ability of the justices to persuade their colleagues on the court is the primary indicator of which opinion will prevail as the majority decision. After the opinions are written and signed off on, the court announces the decision by publishing it. On rare occasions, the justices read their majority opinions and sometimes their concurring and dissenting opinions from the bench. Many legal scholars say the Roberts Court, particularly in the absence of the strong moderate voice of Sandra Day O'Connor, and with the addition of the conservative Alito, has been tilting more conservatively than the Rehnquist Court, in which O'Connor played the pivotal balancing role. But President Obama's 2009 appointment of Sonia Sotomayor, considered more liberal than the justices appointed by President George W. Bush, seems to have altered public opinion concerning the Supreme Court's ideology. Today, half of all Americans consider the ideology of the court about right, while an increasing number, from 21 to 28% between 2008 and 2009, believe the court is too conservative. Paralleling this trend is a decreasing percentage, 30 to 19%, who believe the court is too liberal. Despite the evidence that increasing numbers of Americans believe the court is too liberal, the short track record established by the Roberts courts thus far indicates that the outcome of many cases by the court have had a decidedly conservative flavor. For example, the 2007 decision regarding affirmative action, in which the court ruled that judicial decisions concerning the use of racial criteria in higher education do not apply to public high school admission policies. This decision illuminates a distinct trend of the court today: the justices' willingness to limit the authority of the states and other branches of government. In another example, the Roberts Court weakened a key provision of a landmark campaign finance law, the Bipartisan Campaign Reform Act of 2002, also known as the McCain-Feingold Act, by loosening restrictions on campaign television ads. The court's recent conservatism is also evident in a case in which the justices upheld a federal ban on partial birth abortion, a procedure in which labor is induced and the suction is used to remove a fetus. Many other important cases that the Roberts Court has chosen to hear deal with the balance of power between individuals and government, often reaching a conservative decision by a slim 5-4 margin. Though not divisive, one important case involved a 13-year-old suing her school district after being strip-searched when school officials suspected that she had provided over-the-counter ibuprofen to a classmate. In an 8-1 decision, the court ruled that although it was reasonable to search a student's backpack and other outer garments, a strip search violated the student's right to privacy and was unreasonable. Another more closely divided case dealt with when federal courts may act to enforce federal mandates on states. By a 5-4 decision, the court made it easier for state schools to shed federal supervision of their English language education program, a decision that will affect other state institutions, including prisons. In another 5-4 decision, the court dealt a blow to the criminal justice system in 40 states by requiring the crime lab analysts testify in criminal proceedings, instead of allowing reports written by the analyst to substitute as evidence. At the time of the ruling, laws in only 10 states complied with the ruling. Today's ideological distribution of the Supreme Court has a tilt towards the conservative side, with Justices Clarence Thomas, Anton Scalia, and Samuel Alito, and Chief Justice Roberts reflecting conservative viewpoint, and Justices Sonia Sotomayor and Ruth Bader Ginsburg taking a more liberal stance on many issues. In the center are Justice Anthony Kennedy, a moderate conservative, and Justices Stephen Breyer and Alon and Kagan, moderate liberals.